Hey there, everyone. It's Rob Ryder. 4th day of October, year of our Lord, 2012. And I was putting this together last night so we could talk about Code of Canon Law in 1983, what Title 3, Ways of Avoiding Trials says, and that's in Book 7, Part 3, Title 3, and also Title 4, Proofs, which is in Book 7, Part 2, Title 4. And so I was putting this stuff together, and I got a call last night from a brother in Maryland who told me a little story. So apparently he was talking to somebody yesterday that he knows quite well. They talk about all these kinds of things, whatever these things are, quite often. And his friend he was talking to had just recently heard from a friend of his who was in prison, jail, prison. Okay, I don't have all the details. So the guy that was in prison, however he did it, right, call, whatever he did, talked to this brother of his on the outside, and he told him that an attorney had come to see him. Now this is the guy on the inside, an attorney's coming to see him. I don't know why the attorney's there. Don't know anything about it. But in the conversation, the attorney said to the guy in jail, tell your friend on the outside that whatever he did forced the judge to retire. Tell your friend on the outside that whatever he did forced the judge to retire. Words to that effect. So, right? So now the guy on the outside's hearing this, and, what did the guy on the outside do? Well, he had sent a plea of the crown to the Vicar General. I don't know what the plea of the crown said. I don't know what Vicar General. Don't know more than I'm telling you. But that was what he had done, and the attorney is telling this guy inside. Now, this is an attorney, right, telling this guy in jail, tell your friend on the outside that whatever he did, excuse me, forced the judge to retire. What did the guy on the outside do? He submitted a plea of the crown to the Vicar General. And I'm hearing this from the guy who was told it by the guy that had done it and was talking to that guy on the inside. So there you go. Circumstantial evidence at best. But I'll take it. Maybe I'll hear more. But, I asked, well, is there a chance I can talk to the guy who talked to the guy on the inside that heard this? And we'll see what happens. If not, I'm not going to say anybody's lying. I'm going to say that's probably what happened. I just want to know what he wrote, because obviously, if that's the case, he didn't write it quite correctly because his buddy's still in jail. Right? So, and I don't think we're supposed to send it to the Vicar General. I think we're supposed to send it to the judge of first instance. But the idea is still the same. Plea of the crown, call it what you will, sent to an ecclesiastic court, has jurisdiction over the world, judge retires. So, let's look at some stuff here. That wasn't really ready here. So we're going to be reading through some canons. A lot of these I've already read to you, but I'm going to do it again. Canon 1501. A judge cannot investigate any cause unless a plea drawn up in accordance with canon law is submitted either by the person whose interest is involved or by the promoter of justice. Right? Judge can't do a damn thing unless you enter a plea. What's a plea? Well, one is called a plea of the crown. Could be called a petition. A person who wishes, 1502, a person who wishes to sue another must present a petition, that's what they're going to call it, to a judge who is lawfully competent. What does that mean, lawfully competent? To have jurisdiction over the matter. Everything under the seal of the notary is an ecclesiastic jurisdiction. He's got jurisdiction. In this petition, the matter in disputes is to be set out and the intervention of the judge requested. Okay, so you're going to tell him what happened, what the dispute is, and, what you want the judge to do. Once he is satisfied, that's 1505, once he has satisfied himself that the matter is within his competence and the plaintiff has the right to stand before the court, the sole judge or presiding judge of the collegiate tribunal must, as soon as possible, by his decree, either admit or reject the petition. Yes or no, are we going to take it on or not? Do we have the jurisdiction? Well, let's see how they can reject one. A petition can be rejected only if the judge of the tribunal is not legally competent. Make sense? It is established beyond doubt that the plaintiff lacks the right to stand before the court. Well, if you're baptized, you have a right to be there. If it's under a seal and you're not baptized, you have a right to be there. Right? This idea I'm trying to get across to you isn't drawn along religious lines, it's spiritual lines. Jewish, Muslim, Christian, Buddhist, whatever. If you're involved in a contract and it's under seals, you can take it to the ecclesiastic court. If a notary puts her seal on it, it just became an ecclesiastic document. And then if you didn't follow the provisions of 1504, which basically tells you how to write it, and I've already written some, you can see how I think they're supposed to be written, yet to be determined. It is certainly clear from the petition that the plea lacks any foundation, that there is no possibility that the foundation will emerge from a process. Okay, so these are the reasons it can be rejected. You weren't clear. You got to have a foundation. If a petition, so a foundation would be a right, right? Be the cornerstone, foundation stone. If you're baptized, you got a foundation to start with. If it's under the seal of a notary, you got a foundation to start with. Other reasons it could be rejected. If a petition has been rejected by reasons of defects which can be corrected, the plaintiff can draw up a new petition correctly and present it again to the same judge. Okay, so there's a problem, you can fix it. A party is always entitled, within 10 canonical days, to have recourse based upon stated reasons against the rejection of the petition. The recourse is to be made either to the Tribunal of Appeal, or, if the petition was rejected by the presiding judge, to the Collegiate Tribunal. A question of rejection is to be determined within with maximum expedition. So I'm reading this that they have to tell you that they rejected it, number one, and then you have 10 days to correct it. But if you're going to correct it, you're going to do it to the appeals court. So if I'm sending it to the judge of first instance, which is the diocese, I would send the appeal to the metropolitan, which is the archbishop here in Michigan, is Detroit, to the archdiocese. Or if the petition was rejected by the presiding judge, okay, so if to the collegiate tribunal. So if a sole judge, it sounds to me like if a sole judge rejected it, they do have these tribunal judges there. You can send it back to the tribunal. But we have to figure out what the collegiate tribunal is. I'm sure it's defined someplace in canon law. Now these are interesting. 1506. If within a month of the presentation of a petition, the judge has not issued a decree admitting or rejecting it in accordance with 1505, the one we just read, the interested party can insist the judge perform his duty. It doesn't say how you insist. You can just insist. If you haven't heard in 30 days, yes or no, you can insist the judge do his duty. If notwithstanding this, the judge does not respond within 10 days of the party's request, so after, so what do we have here over time? Has not issued a decree. Okay, within 30 days, right? You can, after 30 days, you can insist that he does, and if he hasn't responded in 10 days, after that, the petition is taken as having been admitted. They're not necessarily going to let you know that they've accepted your petition, which is apparently what happened with these guys in this plea of the crown, because the guy on the outside didn't know anything had happened. Nobody knew anything until a frickin' attorney came up and told the dude in jail, tell your friend on the outside whatever he did, got the judge retired. Well, what did he do? He put in a plea of the crown to the Vicar General. Beautiful. I'm going to show you how common law got into canon law, and it's really this simple. In Canon 1655, in real actions, whenever it is decided that things belong to the plaintiff, it is to be handed over to the plaintiff as soon as the matter has become an adjudicated matter. Real actions can only be heard in the plea in the Court of Common Pleas by the laws of England. Blackstone and Coke both tell you real actions are heard in the Court of Common Pleas, which to this day is in Westminster Abbey, which is where the Archbishop is. But, that's just a diocese. So to me, every diocese has a court of common pleas. And the other court that's there from English law then is most assuredly the Court of Chancery, where you get the original writs under the Great Seal that's kept by the Chancellor. In personal actions, when the guilty person is condemned to hand over movable possession or to pay money or to give or do something, the judge in the judgment itself or the executor, according to his discretion and prudence, is to assign a time limit for the fulfillment of the obligation. This time limit is to be not less than 15 days nor more than 6 months. So if you send a petition in and the judge says you're right, then the other side has got whatever the time frame the judge gives them, between 15 days and 6 months, to do whatever needs to be done. This is very similar to what it says in Michigan if you want to recover property. It says if there's an executory device that's part of this dispute, which would be like a deed of trust, which is a contract that only you've signed, and so it has not been lawfully executed. For it to be lawfully executed, the bank needs to sign it. So you contact the bank and you tell them they have 15 days to execute the contract, or they're in breach of contract. And after 15 days, if they haven't done it, then you get a hold of the ecclesiastic court. And all these things I have covered on different videos before. I'm not really going to go into why these are the way they are. To me, it's just been finding justice. I can point out the defects. I got to find justice. Well, right here in the canon law, it says they have jurisdiction over real actions and personal actions, and those are heard in the Court of Common Pleas. Real action is to determine the rights, title, and interest to land. That would be your body. And personal actions are for your personal property. Movable possessions. Securities. Right? A piece of paper that's moving around, that's a movable possession. It's got your damn name on it. And so they have so much time to do it. And so this thing in Michigan, they have 15 days. DC 104 is the name of the form. DC 104. And I believe that's the form you use to do this process. And then there's a booklet that goes with it that explains what this stuff is and how to fill out the form. Although you can't find the little D district court, the lowercase district court in Michigan, right? It says in there that's where you would take this to. All the good things you can find in this compiled laws of Michigan when it comes to courts are always lowercase. But you can't find those when you go to the courts that we believe that we're supposed to go to. They're all uppercase. But here's some ways of avoiding a trial. Canon 1713. In order to avoid judicial disputes, agreement or reconciliation can profitably be adopted. Excellent. Follow the agreement. Or make it right. Or the controversy can be submitted to the judgment of one or more arbitrators. Right? So we can either agree between ourselves to fix it, we can go to our brother, settle the matter, or we can have it arbitrated. 1714. The norms for agreements for mutual promises to abide by an arbitrator's award and for arbitral judgments are to be selected by the parties. If the parties have not chosen any, they are to use the law established by the Episcopal Conference, if such exist, or the civil law in force in the place where the pact is made. And a pact is a contract. So I don't know what the Episcopal Conference is, but somehow canon law is supposed to have jurisdiction over the UCC. Uniform Commercial Code. Right? Put in Universal Commercial Code, canon law into Google and see if you don't find hits that say that canon law is what created the UCC, Uniform Commercial Code. Well, if that's the case, why in the hell are you going to a different court than the ecclesiastic court? They have a court for canon law. It's the ecclesiastic court, and it's sitting in the frickin' diocese. Their courtrooms aren't in the same courtrooms as the quasi-civil courts, the frickin' religious societies, corporations courts, which are bought and sold, and right? They're corporations. They're not a civil government. And these religious corporations work under civil law of the Roman civil law, but we're talking pagan Roman civil law where there's no God in the courtroom. You go to their courts, there is no God. You go to these courts, it's all about God. That's the difference. You go to canon law court, it's all about faith. Canon 1715, agreements and mutual promises to abide by the arbitrator's award cannot be validly employed in matters which pertain to public good, and other matters which parties are not free to make such arrangements. Excellent. So we go into arbitrators' courts. That's what these black-robed priests are. They're arbitrators. But they cannot be validly employed in matters which pertain to public good. So if it's to good faith, they don't have any jurisdiction. Whenever the matter concerned demands it, the questions concerning temporal ecclesiastic goods and the formalities established are by law for the alienation of ecclesiastic goods are to be observed. Well, the matter in concern is you, so whenever you demand it, because you have temporal ecclesiastic goods, if you were baptized, right, your property, you're part of the Society of the Universal Church of Jesus Christ, if you choose to be. And so they have control of your property. They're letting it be administered by somebody else because you haven't chose to go to the church to have them administer it. You chose the corporation to do it for you. And anyways, in Book 5, Temporal Goods of the Church, 3, Contracts and especially Alienation, right? I got to go read that, but that's where you would go next if you believe this. Whenever the matter's concerned demands, okay, I demand it. In questions concerning temporal ecclesiastic goods, those given to me by faith from the Creator, the formalities established by law for the alienation of ecclesiastic goods are to be observed. Well, that means only the church has jurisdiction. Canon 1716. If the civil law does not recognize the force of an arbitral judgment unless it is confirmed by a judge, an arbitral judgment in ecclesiastic controversy has no force in the canonical form unless it is confirmed by an ecclesiastic judge of the place in which it was given. Okay, so if civil law says, well, the arbitrarial judgment doesn't count unless it's confirmed by a judge. So you got to go to court. Then an arbitral judgment in an ecclesiastic controversy has no force in the canonical form unless it is confirmed by an ecclesiastic judge. In other words, if their ecclesiastic controversy over good faith, over perjury, over sin, over faith can only be determined in an ecclesiastic court. Faith, sin, notary documents, those are all the jurisdiction of ecclesiastic court. If, however, the civil law admits of a challenge of an arbitrarial matter before a civil judge, the same challenge may be brought in a canonical forum before an ecclesiastic judge who is competent to judge the controversy in the first instance. All right, so if they say that you can in the civil law, well then canon law says you can bring it to them also. The same challenge may be brought in ecclesiastic forum before an ecclesiastic judge. So you don't have to answer back into the court that sent you the summons. You would send your answer to the ecclesiastic court and say, receive this summons. It's not under the seal of a justice. Right? They're using color law against me, a living man. And that's fraud on the court. It's a matter of faith. They sinned. They're charging me in my all capital letter name, right? Lots of different things I pointed out before that are the basis for what you would write when you would do your petition, if necessary, to an ecclesiastic court. But if you were to point these things out, so here's the thing. Now, if we instead, you're getting a foreclosure against you, you tell them they produce the evidence that's been recorded, or you're going to turn this over to an ecclesiastic court, and then see how they treat you. And if they don't, well, then you have the evidence that you went to your brother first to settle the matter. They're refusing, right? Now you don't have any blood on your hands when you take it to the ecclesiastic court, and somebody has to be retired. Jurisdiction. This is in a arbitral tribunal, which is, I really believe that's what their courts are pretending to be. In most legal systems, the arbitral tribunal is able to rule upon its own jurisdiction. They can say that they have jurisdiction by themselves. Briefly, this enables them to determine for itself whether the arbitration agreement is valid, whether the tribunal is properly constituted in an applicable law, and the matters are determined by the arbitration under the agreement. So what matters are to be determined by the arbitration under the agreement. They may not, they're going to say, well, we don't have jurisdiction over these parts, but we'll rule on these. They're going to rule on the ones that don't have anything to do with faith. And they're going to say that they're the arbitrator. I remember listening to Gordon Hall once, and he had a guy went into a court case or something, and the guy came out, or they were sitting out there, and the judge came out, and he had his the front of his shirt or his gown undone, and there was Gordon Hall's group of people sitting in there, and one other group of 3 people or something like that, and the judge walked out and said, "Hey, I'm just the arbitrator," or no, "I'm just the facilitator." That's how he put his position. He was just the facilitator. So somehow they're using this against us. But there's two kinds. So from that, then there's 2 kind of hearings, right? You got an arbitration hearing, can be either procedural or evidentiary. As in a court system, procedural hearing focuses exclusively on how the proceedings are to be conducted. So when they say a hearing, since we don't know which kind it is, but it's an arbitration hearing because you're in an arbitration court, that's when they may say, well, this is a hearing, not a trial. Which a sister heard when she asked an attorney's talk and given his side of a story, and then she said, well, is that your testimony? And the judge jumped out of her chair and said, didn't have to answer it or whatever, and said, this is a hearing, not a trial. So it's a procedural hearing that they were in, because an evidentiary hearing is commonly called a trial. Cases for the declaration of nullity, sacred ordination. The right to impugn the validity of a sacred ordination is held by a cleric himself, or by the ordinary to whom the cleric is subject, or by the ordinary in whose diocese he was ordained. I think this is what happened to the judge. He lost his clerical office. And that can only happen by the ordinary, or the ordinary in whose diocese he was first ordained. The petition must be sent to the competent congregation in which to decide whether the case is to be determined by the congregation or of the Roman Curia or by the tribunal designated by it. So you're going to get the Roman Curia involved in this. They got the Supreme Court of the Catholic Church who's going to determine where this case is going to be heard. Once the petition has been sent, the cleric is by law itself forbidden to exercise orders. If the congregation remits the case to a tribunal, the canons concerning trial in general and an ordinary contentious trial are to be observed, unless the nature of the matter requires otherwise, and without prejudice to the provisions of this title. Okay, so they send a petition out, it's going to be a court case, just like an ordinary contentious trial. In these cases, the defender of the bond has the same rights and is bound by the same duties as the defender of the bond in marriage. All right, so I don't know what that means, but there's a defender in the bond. He's also called the defender of the bond, is also the promoter of justice, wearing a different hat. In one hat, he's a prosecutor. when he's the promoter of justice. After a second judgment confirming the nullity of the sacred ordination, the cleric loses all rights proper to the cleric state and is freed from all its obligations. Basically, he's banished. Now, the attorney said, the judge had been forced to retire. We don't really know what that means. Retired with what? And I don't even know if they have anything to do with each other. It just depends on if they're clerics, but they sure act like they're priests. Everyone says they're a priest. Well, if they're a priest, there must be an ordained priest. And this is how canon law handles those that are going to lose their clerical office. Okay, so in Book 7, they get this section on proofs. Right? What is proof and so forth. So I'm going to go through this relatively quickly. The onus of proof rests upon the person who makes the allegation. The following matter does not require proof. Matters which are presumed by the law itself don't require any proof. Right? If the law says two parties must agree for a contract to be valid and the bank hasn't signed your deed of trust, then they're in breach of contract. And they're never going to sign your deed of trust, so either sign the deed of trust or send me back my securities, their conversion and their gain. That's what you're asking for. We're not asking for money. We want our securities back, or if they've been converted, their value of the conversion and their gain. Or sign the damn deed of trust. Mortgage, whatever it is, it's a security agreement. It's an agreement. Both parties must agree. They never frickin' acknowledged it. Yet there it sits in your property record saying that you've signed it and acknowledged it. It's acknowledged before a notary. But the bank hasn't, so frickin' tell them to either do it or send you back your property. And tell them they have 15 days or you're going to take it to an ecclesiastic court. Right? That's reconciliation. Make it right. Or I'm going to my brother first, or I'm taking it to an ecclesiastic court. And you can deal with the vicar general after the bishop gets done with you. Canon 1527. Any type of proof which seems useful for the investigation of a case and is lawful may be admitted. Excellent. A party submits that proof which has been rejected by the judge should be admitted by the judge to determine the matter of maximum expedition. If a party submits that proof which has been rejected by the judge should be admitted, the judge is to determine the matter with max. Okay, so you can say, well, yeah, basically you can force him to take it, or he needs to tell you why he isn't, but it has to be done quickly. He's got to let you know that he isn't accepting your proof. If a party or witness refuses to testify before the judge, that person may lawfully be heard by another, even a layperson appointed by the judge, or asked to make a declaration either before a public notary or in any other lawful manner. So if you do a declaration in front of a public notary, that is a lawful manner. Ecclesiastic courts have jurisdiction over things under notary seal. 1529, unless there's a grave reason the judge is not to proceed to collect the proofs before joinder of the issue. Yeah, what does that mean? The acceptance by the opposing parties that a particular issue is in dispute. At common law, joinder of issues occurs when one party pleads that an allegation is true and the opposing party denies it, such that both parties have accepted the particular issue is in dispute. Well, the only way you can find that out is to ask the other guy's side of the story, to summons them. The judge may always question the parties the more closely to elicit the truth. This is under a declaration of parties. He must do so if requested by one of the parties or in order to prove the fact which public interest requires to be placed beyond a doubt. So this is called, remember this thing here about in order to prove the fact, right? He may do so if requested by one of the parties. We're going to see what that means down here in proof in just a second. But yeah, before I go any further, just let's click down here. This is on the new advent on proof. Proof is the establishment of disputed or controversial matter by lawful means or arguments. Canon is enumerated 6 kinds of perfect proof. the unshaken deposition of two witnesses who are above all suspicion, a public document, or other instrument having force of public document, as for instance a certified copy of a public instrument, a conclusive presumption of law, a decisive oath, judicial confession, evidence of a notary or notoriety of a fact, notary seal. But this decisive oath is a certain kind of oath where one of the parties has to tell the judge, I demand you put him under oath and ask him these questions. That's how I understand it. So, shoot, man, where am I? So that would be this here. He must do so if requested. So, it's a decisive oath. You're going to request that the other side be put under oath to answer the question. A party who is lawfully questioned is obliged to respond and to tell the truth. Guess what? It's under oath. If a party has refused to reply, it is for the judge to evaluate what, as far as the proof, the facts is concerned, can be deduced therefrom. Well, if you give them a copy of a recorded a deed of trust that you have signed and acknowledged, and it hasn't been signed and acknowledged by the bank, it's pretty obvious they haven't done it. It's public record. You can go down the public record and see the copy, and it's going to show it's not been acknowledged by the bank. Therefore, there is no agreement. And until they sign it, it's bank fraud. It's a breach of contract and a false obligation. So you're not suing for money. You want your property back. You want the court of law to say you're right. And when the court of law says you're right and law is on your side, equity will follow. Unless a grave reason suggests otherwise, in case which public good is at stake, the judges to administer the parties an oath, they will tell the truth, or at least that what they have said is the truth. In other cases, it's left to the prudent discretion of the judge to determine whether an oath is to be administered. The parties, the promoter of justice, the defendant of the bond, may submit to the judge propositions upon which the party is to be questioned. So you can say, as one of the parties, you can say, I want these questions asked. And tell the judge what you want to find out. A judicial confession is assertion beyond a fact against oneself concerning a matter relevant to the trial, which is made by a party before a judge who is legally competent. This is so whatever the assertion is made in writing or orally, whether spontaneously or in response to the judge's questioning. So, it's good to get a judicial confession from them. In a private matter where the public good is not at stake, a judicial confession of only one party relieves the other parties of the onus of proof. In cases which concern a public good, however, a judicial confession and declaration by the parties, which are not confessions, can have the probative value is to be weighed by the judge in association with other circumstances of the case. But the force of full power cannot be attributed to them unless they are other elements which are wholly corroborate them. All right. What does all that mean? Okay. If you confess, so if you say you're guilty, that's why I ask you, guilty or not guilty. If you say you're guilty, you just judicially confessed. And that's good enough. Unless the public good is involved, which is you, then that isn't enough, right? There has to be other evidence besides that. So they're showing you that there's a way out of what happened in civil law, in my opinion. It is for the judge, having considered all the circumstances, to evaluate the weight being given the extrajudicial confession which is introduced into a trial. So this is where you confess outside of court, where you sign a declaration on your tax form, right, under penalty of perjury. None of that shit means anything in an ecclesiastic court unless there's other evidence. Just saying you're guilty to get out of something because your attorney said you should doesn't mean that you're guilty, and these people know this. Documentary proof. In every type of trial, documentary proof is admitted whether the documents be public or private. So public and private documents can be admitted as proof. Public ecclesiastic documents are those which an official person draws up. To me, that's, an official person drew up the frickin' deed of trust, made it a public document. Public civil documents are those which are legally regarded in accordance with the laws of each place. I'd have to say that is what a deed of trust is. That's what they're taking you to court on. All other documents are private. Unless it is otherwise established by contrary and clear arguments, public documents constitute acceptable evidence of those matters which are directly and principally affirmed in them. They say what they say. If they say they haven't signed it, there really isn't anything to say other than, yeah, you haven't signed it yet. The law says both parties must agree for it to be a binding contract. So you either sign it, bank, or you're in breach of contract. If you're not going to sign it, then send back the securities because it's a false obligation. A private document, whether acknowledged by a party or admitted by a judge, has the same probative force as extrajudicial convention against its author or the person who signed it, and against persons whose case rests on that of the author or signatory. Against others, it has the same force as have declarations by the parties which are not confessions in accordance with Canon 1536. Okay, so a private document, its value is going to be determined by the judge, basically, for or against the guy that signed the damn piece of paper. Documents do not have probative force at a trial unless they are submitted to the original form and the authentic copy, or an authentic copy, and are lodged in the office of the tribunal so that they may be inspected by the judge or by the opposing party. So you either need to have a certified copy or the original, or whatever authentic means. If I have the original, I send out a copy of the original. I still have the original. I can authenticate all the copies. I have the original. So I'm going to keep the original and send them a copy. Said, consider this an original. An authentic copy of the original. If you put your original into the Register of Deeds office in the county, then that's the original. But your certified copy now is a certified copy of a public record. So if it's not in the public record, like that, but you have the original, then you have an authentic copy you can give them. No one is obliged to exhibit documents. Okay, you can read all these things. I'm going to get this done. Let's see. Witness and testimony. Witnesses must tell the truth to the judge who is lawfully questioned by them. So these are all the different kinds of proofs that can be given, right? So a witness is a kind of a proof. Everyone can be a witness unless expressly excluded, whether wholly or in part, by the law. The following are deemed incapable of being witnesses. Okay, so it just explains who the different kinds of witnesses are. The summons of a witness is effected by a decree of the judge lawfully notified to the witnesses. So if this was to actually go to a trial, the judge is going to send a summons under the Great Seal from issued by the Court of Chancery, and it's not going to be a show cause. It's going to be a we command. It'll be a decree. We demand you show up with the damn records. Right? That's the kind of summons they're going to send. A we command you show up with the records. Okay, and then if they need to be examined, there's different ways it's done. Cardinals, patriarchs, bishops, and those who in their own civil law enjoy similar favor. I wonder who that could be. Who plays these parts in the ecclesiastic courts? Cardinals, patriarchs, and bishops, because this guy's an apostle, a bishop. I'm not really sure who the patriarch is, but I'm going to say the Pope and the cardinals, right? These are all apostles in the universal church of Jesus Christ. So who in the civil law is playing the same thing in pagan Roman law? Well, them black robe priests are. The parties can't be present in the examination of the witness unless, especially when there is a question of private interest, the judge has determined that they can be admitted. Okay, so you can't be present unless the judge says so. Yeah. Credibility of evidence. The deposition of one witness cannot amount to full proof unless the witness is a qualified one who gives evidence on matters carried out in an official capacity, or unless the circumstances of a person's or things persuade otherwise. Is not who gives evidence on matters carried out in official capacity. So if somebody puts a notary seal on something to say, yeah, I notarized it, that document's got foolproof evidence. So here's the 6 things again. Let's go look at them real quick. Confession, the acknowledgement by a person that what is charged or asserted by his opponent is true, is judicial or extrajudicial. Judicial confession is the best of proofs. Get the guy to confess in front of the judge. And then there's these extrajudicial types. Instruments or documentary evidence. A public instrument is one drawn up by a public official that is with the required formalities. Okay? Then there's different kinds of presumptions. Two kinds, rebuttable, which may be set aside by contrary proof, and conclusive, against which no direct proof is admitted. A conclusive presumption. It's presumed that you have to sign the damn contract for it to be binding. Oaths. Oaths as proof are decisive or necessary. A decisive oath is given by the judge when the private interests are in question to one of the litigants at the insistence of the other. The case is decided in favor of the one taking the oath. If he refuses to swear, sentence is pronounced against him. Right? So if the guy will refuse to swear to the proceedings, the sentence is pronounced against him. That's how it's done in an ecclesiastic court. The necessary oath is given by the judge of his own initiative, not at the request of one of the litigants, to complete imperfect proof, and is called supplementary, or to destroy the force of circumstantial evidence arising especially from current rumor against the accused, and it's called purgative. Purgative oaths, accusatory oaths. Again, oaths have got lots of definitions. Go to Bouvier's dictionary. Oaths is the very first listing in oaths, and there's 27, 28 different kinds of oaths listed, or separate entries. Okay, and you got public reports, and you got evidence of facts, evidence or notoriety of a fact, when it is so open and evident that it cannot be concealed or denied, needs no proof. Hence, a judicial inspection of visitation of a corpus delicti is often of an advantage. Under this head might be mentioned the opinion of experts, who are appointed by judges to examine certain matters and to give expert testimony concerning the same. The rules. Proof must be clear, specific, and in keeping with the charge or point at issue. So the only proof they care about is what is it you're complaining about. They don't want to know your frickin' story. What's the problem? Well, I was summoned to court on a summons from a private court that hasn't been before a justice. They're trying to use color law against me, a living man, and that's fraud. That's what I'm complaining about. Here's the proof. Show them a copy of the summons. Here's some more proof. Here's the complaint that's not under the seal. Nobody's taken an oath to the charges. Oh, comparisons. Notoriety is the quality of the states of things that are notorious, whatever is so fully or officially proved. Ordinarily, it is equivalent to public, manifest, evident, known. All these terms have something in common. They signify that the thing, far from being a secret, may be easily known by many. Public records. Notoriety is addition to this common idea, involves the idea of a indisputable proof, so that what is notorious is held as proved and serves as the basis of the conclusion and acts of the authority, especially judges. To be as precise as possible, public means what anyone may easily prove or ascertain, what is done openly, what many persons know and hold as certain is manifest. Anything in the Register of Deeds is public proof. It's full proof evidence brought into this court, used as your evidence, will be seen as full proof evidence. Whatever is easily shown and is known by a sufficient number of persons to be free from reasonable doubt is a notorious fact. Notorious is then used as more or less synonymous with official. Such also are facts recorded in official documents as civil or ecclesiastic registers of births, deaths, or marriages, notarial records. These are all considered proof. Full proof. The best kind there is. When a fact is admitted as notorious by a judge and in a general and competent authority, no proof is required. But it is often necessary to show that it is notorious, as the judge is not expected to know every notorious fact. Okay, so if it's admitted that both parties need to agree to a contract, the judge isn't going to deny that, but you need to give them the proof that, well, here's one where they didn't do it. Well, you're right. The notoriety has to be proved, like any other fact alleged in a trial, by witnesses or instruments, that is, written documents. The witnesses swear that, in fact, the question is publicly known and admitted beyond dispute of their locality or circle. So it can either be done by witnesses or by documents under seal. Documents consist especially of extracts from official registries in the copies of authentic judicial papers, for instance, a judgment, or notarial papers, also known as notarial acts, drawn up by public notaries on the conscientious declarations of well-informed witnesses. Canonists have variously classified the legal effect of notoriety, especially in matters of procedure, but ultimately they may all be reduced to one: the judge, and in general the person in authority, holding what is notorious to be certain and proved, requires no other information, and therefore both may and ought to refrain from any judicial inquiry, proof or formalities which would otherwise be necessary. He doesn't need to have a trial. You gave him the frickin' proof. He can just go ahead and pass the judgment. Well, we're going to find out. Such is the true meaning of the axiom that in notorious matters the judge need not follow the judicial procedures. Give them the proof. None of these essential solemn amenities of the procedure should ever be omitted. The most interesting application of the effect of notoriety in criminal matters is the connection with the pagris delictus. When the accused is caught in a criminal act, they self-confessed in the damn paperwork that they're doing color of law against a living man to take his property. It's a falsehood. Nothing else needs to be proved. In which case the judge dispensed from the necessity of any inquiry. He can just go to work. Okay, well, I got kind of rushed here. I apologize if I talk too fast, but I had a phone call. I got to take care of something. So we'll leave it at that. More later. See y'all soon.